Hello, Ruben Alejandro, Horace Mann League President, welcoming you to the next topic in our podcast series. Our podcast series was developed to help bring critical issues that affect public education with noted authorities that are experts in the field and topics. We invite you to go ahead and enjoy this topic and go ahead and share it with friends, share the information, share the podcast, and help make education the cornerstone of democracy. Thank you and enjoy.
Hello, and welcome to the Horace Mann League's podcast series. My name is Jean Collins, and I'm the Assistant Executive Director of the Horace Mann League. The Horace Mann League is an honorary association of superintendents, professors of education administration, association leaders, and others who believe the common public school is the cornerstone of our community and our democracy. To mark its 100th anniversary in 2022, the League has launched a series of podcasts in which school leaders, educational researchers, and other experts share their experience and insights into the challenges facing public schools, as well as the value of public education and how the nation's schools have helped address the problems and opportunities facing our nation. All Horace Mann League podcasts are listed each week in the HML Post and also can be found on YouTube or Spotify, as well as on the Horace Mann League website. It is now my pleasure to introduce our moderator, Jimmy Minicello, Director of Communication and Public Relations at AASA. Thank you, Jimmy, for moderating today's podcast, and I'll pass it to you to introduce our guest today.
Welcome to the Horace Mann League podcast. And on behalf of all of us who advocate for public education, we're so happy you can join us. The United States Supreme Court made two decisions that have huge and immediate implications for schools. The first was a Maine case, Carson versus Macon, which in a 6-3 decision found that tuition students must not discriminate against religious schools. The second, a Washington state case, which found that a football coach could lead prayer at the 50-yard line. To discuss these cases, we have two of the nation's leading scholars of school and constitutional law. I am pleased to introduce Derek Black and Jessica Levin. Mr. Black is a professor of law at my alma mater, the University of South Carolina, and Ernest F Hollings Chair in Constitutional Law. He's the author of Schoolhouse Burning, Public Education and the Assault on American Democracy, as well as Ending Zero Tolerance. He's a leading lawyer on religion and schools. And we also have Jessica Levin, the Director of Public Funds for Education used to support public schools, a national campaign to ensure that all public funds are used to support public schools. She is also a senior attorney at Education Law Center. Mr. Black and Ms. Levin, thank you so much for joining us.
Thank you for having us on.
Yes, thanks very much. It's a pleasure to be here.
To get us started, Mr. Black, could you briefly summarize these decisions?
Well, the Carson case involved a relatively unique program in Maine whereby they would fund private school education in remote areas of the state. For those who aren't familiar with the geography there, it's pretty sparsely populated, and some of the districts don't have enough students to operate their own public high schools. So there's a state law that says the district can either enter into a contract with a neighboring school district, public school district, it can enter into a contract with a private school, or it can let students go out and look for a school, public or private, and it will reimburse the tuition of that. But there was one sort of exemption in that, which is that if they're going to engage with the private schools, those have to be secular schools. They can't be religious schools. And maybe it's even more narrow than that, because some religious schools actually do participate or did participate in Maine's program, but it was really only those religious schools that wouldn't provide a secular education that were excluded. So the question before the court was, does this violate the free exercise clause of the Constitution? And the court held that it did. It held that it was what they call a status-based discrimination against religion, and therefore was prohibited. The court unfortunately went one step further and also ruled out this idea that the state might be able to restrict funding based upon how a school uses it, which is to say, well, you can give it to a religious school, but they can't spend it on the Lord's Supper, sort of religious type things at school or chapel time or any of that. The court said no. That's not a limitation either. So the state can neither discriminate based upon the status of an institution, nor can it limit how the institution uses those funds, at least with sort of the word religion being part of it. So that's what Carson does. Sort of opens up those public coffers, not just to private schools, but private religious schools in Maine and potentially elsewhere. Now, Kennedy versus Burton is an interesting case on facts because it had bounced up and down through the courts so many times with additional briefing on the facts. But the shortest version of the story is that there was an assistant football coach who was leading prayer at the 50-yard line at the end of football games, and other students were joining him there, and the school had told him to stop doing that because as a state official, a state employee with charge over the children, they believe that his leading this prayer, particularly given his role over the students, could have a coercive effect and that it would violate the Establishment Clause. So, but the court said, however, that we can dig into the facts later if others are interested, but the court said, look, he was kind of on his own free time at this point in the football game. The game was over. If others want to join him, that's on them, not on him. And that he had a free exercise right to lead this prayer, and therefore, what he was doing didn't violate the Establishment Clause, and to stop him from the prayer would violate his free exercise of religion rights. And so now there's certainly more flexibility for individuals, I suppose, to lead prayers in a public setting, in a public place, at public schools.
Jessica Levin, let's turn to you. What are the implications of public funds going to private schools?
Well, Jimmy, there are so many implications. So I'll just start out by giving us a few of them for your listeners to consider. But there are so many negative implications of public money being diverted to private schools through what we call private school voucher programs. I do want to note that the program that was at issue in the Carson case in Maine, we don't consider to be a private school voucher program. That was a unique program, as Professor Black said, to fulfill Maine's constitutional duty to provide a publicly funded education to students who are in rural parts of the state where a public school wasn't operated. Whereas a voucher program is a separate statutory scheme to provide funding for an additional private school option on top of the public schools that exist in all states. So that's not the same situation, but let me talk for a second about private school vouchers generally, because there are so many negative implications. All the implications are negative of private school vouchers. So one is that they divert scarce resources from our public schools. And as your listeners probably know, we have many, many areas in this country in which public schools are chronically and severely underfunded and cannot afford to lose precious funding being diverted to private schools. And that's exactly what private school vouchers do. So that's one implication. Another is the implications for student outcomes, for educational outcomes, because proponents of school privatization will often say this will lead to better outcomes for our kids. But study after study shows that vouchers do not lead to improved educational outcomes. And actually, they often harm educational outcomes. Kids do worse when they take a voucher. Another really important one that I want to mention is that students have fewer protections against discrimination if they take a voucher to attend a private school. So this is in a lot of areas. It may be on disability status, on LGBTQ status, their religion. And so there's a lot of room for discrimination when we divert public funding to private schools. And then finally, the last one I want to mention now is that voucherization can cause or exacerbate racial segregation in schools. Private schools overwhelmingly serve white students, and funding private school vouchers can increase segregation in both public and private schools. So just to get us started, those are a few of the very dangerous implications of diverting public funds to private schools.
For both of you, and Jessica, we'll start with you on the next question. Are there dangers of public funds oozing into support for religious schools, and can it be prevented?
Yes, many dangers. So, I mean, many of the same dangers that I mentioned with voucherization, creating programs that divert public funds to any private school. When we divert public funds specifically to religious schools, one thing that can really implicate is the discrimination that I was talking about. That's not at all to say that all religious schools have discriminatory policies or practices, but some do, many do around the country. And so when we publicly fund religious schools, that means that states sometimes will be funding discrimination, for example, against LGBTQ students and families, or against families that don't practice the religion or profess the faith tradition of that school. So a lot of dangers of funding religion, which is why we have established both in the federal constitution, it has the establishment clause that Professor Black was talking about. And then in many state constitutions, there are constitutional firewalls to protect our public education funding and prevent it from being diverted to religious schools and to private schools in general. And those firewalls and protections are also under attack around the country.
And Professor Black, anything to add to that?
No.
If one religion can call down money to support their beliefs, could this not be an avenue to support some rather non-traditional views?
Well, I mean, I think a lot of the folks advocating for vouchers sort of couch it in this idea that it's going to create pluralism, sort of pluralistic, sort of lots of different views, and people can sort of find their own. I guess there's a scale problem with that idea, first of all, that if you really are of a minority faith or a minority view, I think operating a full-scale school that speaks to those issues is pretty highly unlikely. So the idea that somehow this is going to create more diverse views in the private sector, I kind of doubt that. I think what it seems more likely to do is to promote extreme ideas in the private sector. Now, certainly there are fine private institutions that follow all the rules and treat students the way we want them to be treated, as Jessica said. But I think what we see, particularly now with the assaults on public education, the complaints about critical race theory, the complaints about treating LGBTQ children fairly, that what these policies are also doing is giving an exit option to people who are hostile to public values. And I can see those folks sort of being in their own silos in schools, because they're actually leaving, not necessarily because of some obvious religious reason, but they're just sort of upset with what I would call, sort of common values in the public schools. So I think there is a danger of exacerbating fringe values and sort of fringe religious views by facilitating and incentivizing students and families to leave public schools.
And Jimmy, I would just add that I think the other part of your question that I didn't address was, can we prevent this? And I think in the education context, the way to avoid publicly funding religious schools now is to not fund private schools at all. So the Supreme Court's decision in Carson versus Macon, and then other recent decisions like the Espinoza decision in 2020 have sort of made clear that if a state funds private schools, it has to include religious schools, at least on the questions, the situations that have come before the Supreme Court so far. But the Supreme Court has also made clear another very important principle, which is that states do not have to fund private schools at all. So there is no requirement for states to have voucher programs. That's really important for people to know, and for policymakers to know that they do not have to have voucher programs, that they shouldn't have voucher programs. It's a very bad policy idea and also illegal for many, many reasons, as we argue in a lot of our cases. But if they do go down that route, they will be funding religious schools as well. And, the discrimination that comes with it, or the dangers that Derek was just talking about.
Yeah, I would only add on, and I think that's right. They can't exclude religious schools, but I do think if what you have is a voucher program and now you are funding religious schools, I don't think that means the state should sort of throw up a white flag and abandon all of its values. I think the state can still set standards that require admission on a non-discriminatory basis on any number of things and have conditions about special education students. So I think the clearest solution is just don't have them at all. But what I worry is that we're now moving to a much worse situation. We're going to have them and they're going to be completely deregulated in all respects. I don't think that's the right direction for states to go. And I am somewhat sympathetic to their instincts only because this has been a hard Supreme Court to please. It almost seems like no matter what kind of good idea you can come up with, they don't like it too much. But I am confident there are good ideas out there that the states can stick to in terms of anti-discrimination and quality education in particular, if they insist on going down the road of vouchers.
Now, if
Great point.
private schools are to receive public funds, can they be held to the same standards as public schools? And for that matter, who would monitor compliance?
Well,
Yeah, go ahead, Jess.
go ahead, Eric.
Well, I was just gonna, yeah, I mean, absolutely, they can be held to the same standards. I think the key word is can. I mean, there's no stomach to hold them to the same standards, which is why they're creating them to begin with. And so it ends up being more often than not a blank check. But I can tell you, for instance, here in South Carolina, the votes were seemingly there to pass a bill. And at the very last moment, the final hours of the session this year, I think it was the Speaker of the House or the Chairman of the Education Committee said, well, if we're going to do this, and he already supported the board, he said, if we're going to do this, for goodness sakes, they ought to have to take the same tests that we claim are so important in the public schools. And that ended up being a poison pill. That killed it, right? Because they didn't, the voucher supporters didn't want vouchers and tests. They just want vouchers in a blank slate. So they can be held to the same standards, but those advocating for vouchers are not too interested in those standards, shall I say?
Yeah, exactly. I think what we've seen from experience is that they are not held to the same standards on so many different vectors or measures. So voucher laws themselves, the statutes that legislatures pass to create voucher programs, they usually include very minimal oversight and accountability provisions. And that is on both academic quality standards, like teacher certification, curriculum standards, things like that. Also on accountability, fiscal accountability and governance standards, things like audits, what do you do with the money, who has oversight over that, et cetera. And that contributes to the problems with vouchers, not helping with student achievement, with the public not knowing where their money is going or whether kids are being educated at all with that money. And it means that voucher programs are notoriously ripe for abuse, fraud, and waste of public funds. And this has been found in different places like Florida, which spends the most on vouchers, over $1 billion a year now that Florida spends on very unregulated voucher programs. That kind of fraud and abuse has been found by what little oversight has been done in places like Arizona. They find a lot of fraud. And so we know from experience that these programs are not being regulated and we don't know what's happening with the money. And moreover, many voucher laws, increasingly, we see them explicitly including provisions in those laws that preclude the government from regulating private schools. They say things like, this law does not give the government more power to regulate private schools, or private schools explicitly do not have to change their practices or their creed or their policies or their admission standards to participate in this program. So it's not only, it's not just an oversight that these things are left out, pardon the pun, but it is intentional to not put any regulation on the private schools that will now be eligible to receive millions of dollars in public funds.
Yeah, and I can't speak for 48 other states in the District of Columbia, but I would say that the Supreme Court effectively has put Vermont and Maine's feet to the fire, that it is time to put up or shut up. Maine was in the Supreme Court saying that the only reason why I had this program was to discharge its constitutional duty to deliver a public education, that it was trying to secure an equivalent public education in the private sector. If what they said to the United States Supreme Court is true, then there are only two options remaining for Maine, it seems to me. One is to end the program and build a public high school in every district and state, or number two, to create the type of oversight to fund the type of agency work of the Maine Department of Education, same thing at Vermont, to make sure that actually what students are receiving in these private schools that are funded with public dollars is the equivalent of public education. And if those private schools can't deliver it, then they should kick them out of the program.
Now, considering what you just talked about, Professor Black, do you foresee this or these decisions as a sign of things to come?
Well, I hope it's a sign of things to come in Maine and Vermont. I think, again, if they're going to honor their own words, then the answer is yes. And I hope it's a sign of things to come in a lot of other states. I mean, I do think that there are people across the country who are concerned with appropriate fiscal use of public dollars. And I think what the Supreme Court is suggesting is you don't really making clear is you don't have much control over that. And we really need to get serious about what we're spending our money on. So I hope it's a sign of things to come. But I'll tell you the other side, and maybe has more basis for it, thinks it's a sign of things to come for them, because they keep going to the Supreme Court and they keep winning. So, there are other public programs out there that they have their sights on. They have their sights on using the doctrine in Carson and Espinoza to say, look, we think religious schools should be able to operate public charter schools as well. Now, I'll give you 101 reasons, and Jessica will give you another 52 as to why I think that would be unconstitutional. But I can tell you that the religious choice advocates are coming for your charter schools too. And so we'll see what the fallout is.
Absolutely. Derek put it really well, but I think Justice Breyer mentions that concern in his dissent in the Carson case, where, about this concern about opening the door to religion in other parts of public education, especially charter schools, that pro-voucher groups that want to break down these First Amendment protections in the realm of public education will argue that there have to be religious options in public education, basically. And, we and so many others across the country will vigorously fight that. As Derek said, there are a million reasons why that it should be illegal and is illegal. And the decision in Carson was really narrow. It dealt with this unique program in Maine that only has a counterpart in New Hampshire and Vermont. But the spin from the privatizer side will be that it's a big victory, that it opens the door to these other areas of public education, and there needs to be very assertive pushback on that idea.
And I'll add to that. I mean, regardless of what happens in the court, I think maybe the biggest harm is the narrative that's being spun here, right? That somehow or another the state is discriminating against religion in Maine and in Vermont and other places, and that children should be able to take their take public dollars and spend them wherever they want. Well, I can tell you that although I literally believe it is laughable, we see the Wall Street Journal running op-eds by Columbia Law School professors claiming that based on what they've been reading in Supreme Court cases, they think there's a problem with public education itself, which is to say that compelled attendance that only pays for one option in the public school, they claim that violates their free exercise rights. Now, I don't think they have a valid basis for it, but that type of language is corrosive, it seems to me, in terms of our commitment to public education, to somehow suggest that our public education system is the oppressor, and we ought to just be able to tear it down and start up little fiefdoms elsewhere with our public tax dollars that were designed for public schools.
Yeah, that's a great point, because it's the public schools that have to welcome all students and have to meet the needs of all students. And people have long had the right in this country to choose to attend private school and pay for it themselves, and nobody is challenging that. But what is being challenged is the diversion of our limited public funds, our precious resources for this essential public good of public schools being diverted to private schools that do not have to welcome all students, that do not have to provide them with the services that they need to thrive. Take students with disabilities, for example. School choice is really choice for the school, for the private schools. It's their choice to pick and choose students and discriminate against students. It is not choice for families.
If we could switch gears for a minute or two, back to the case regarding the football coach. Can a student not end up on the bench if the student did not take a knee? And what kind of social pressure might or could happen?
Well, I mean, there's enormous social pressure in these situations, which is why, the court recognized in an opinion written by Justice Kennedy about 15 years ago that these sort of public prayers, particularly with young folks, have a coercive effect, that the student, if they're the only one not standing, if they're the only one not participating, is going to feel compelled to participate, and that's just not a choice that you should put kids to. And so they struck down a sort of high school graduation prayer. They also struck down a student-led prayer over the microphones at a high school as well, because of these coercive pressures. And so there certainly is that. And it seems to me there's no place, quite honestly, that's more coercive than a football field, it seems to me. You're there to be a star, it seems to me. You're there to get the affection of the coach, who has the final decision as whether you play or not play. And again, that's not to say that necessarily the coach's intent is to coerce. I'm not trying to cast aspersions at anyone who engages in prayer, but you understand why a young person feels the need to follow the lead of an older person, and therefore there is that coercion. So unfortunately, the court did two things in the Kennedy case, which is to say, number one, there's no evidence of coercion. I thought that at the very least they could have remanded the case to the lower courts to really delve in to this coercion issue. And apparently there was some evidence, I thought, or at least some anecdotes. So to me, before you just bless this, I think you should look at coercion. But the other thing that the court did, which people, including myself, looked like the court was recharacterizing the facts to fit the result they wanted to, was to say, look, the game is over. Students can do whatever they want to. There's no coercive effect here. There's no one to sit on the bench. The game is over. They could have went home. They could have did whatever. And the coaches are free too. That this is kind of the idea being this is sort of an unsupervised thing. And if students want to voluntarily, go to the midfield in prayer, well, there's no coercion there. Now, I can tell you as a young person, or a formerly young person, when the coach says there's voluntary workouts on Sunday, you go to the voluntary workout on Sunday. The coach says, well, it's not a scheduled practice, but we're going to run some laps around the school at the end of the school day. And there's not going to be any buses. You go, you run, and you figure out how to get home. And the idea somehow or another that a coach going to the middle of the field and praying when it's over, particularly when he'd made such a big show and fight over it, the idea that he didn't expect students to join him, it seems to me to be disingenuous.
And Jessica, anything to add to that?
Yeah, it's very well put. It's very concerning.
Well, I'd like to ask just one more question, and that is, if you were to sum up what we just talked about for those who may have just joined us late, Professor Beck, let's start with you. What would you say?
Well, look, Jessica in particular, and me as a minor sidekick, we're in there trying to fight and support and help schools and states find a way to do this right. But I will tell you, the sum up is not a pretty one, which is that what we have seen is a continual expansion of the court's idea of what it means to engage in the free exercise of religion. And that is a broader and broader right, which sort of narrows the state's limits. At the same time, we've seen the court shrink over the past 20 or so years what amounts to an establishment clause violation. So if you're thinking about sort of, which way the pendulum has swung, it has swung to a version in which individuals have quite expansive free exercise rights, even when they intrude on state policy, and the state has very little power to stop that. And that's disconcerting to those who believe that public schools should be open and welcoming to all folks, regardless of faith, religion, race, etc., and also disconcerting in the private sector as well, insofar as the claim is we're trying to create equal opportunities that are same for everyone in the private sector, and that just isn't the case. So unfortunately, the pendulum is swinging in the wrong direction.
And Jessica, anything from you?
Yes, I mean, on that theme of sort of the broader implications, what I would leave with is that I think the Supreme Court's decisions that we've talked about today, the two decisions, Carson and Kennedy, they're not isolated from other really concerning judicial decisions in recent years that I think have eroded our constitutional rights. And just like attacks on public education in American society are not an isolated phenomena, they're part of these larger attacks on public institutions and the public good. But the positive news is that there are so many people out there, at the forefront, students, parents, teachers, community members, but then also in support, professional advocates, members of the academy like Derek and like Bill Mathis, even lawyers who are ready and willing to stand up for these public institutions, with public schools being at the center of all of that and at the center of our community. So I know your listeners are chief among those public school advocates, and thank you for the opportunity to talk to them today.
Well, it's been a fascinating conversation, and I would just like to, on behalf of the Horace Mann League, thank both of you for joining us. Professor Black of the University of South Carolina and Jessica Levin of the Education Law Center. I learned quite a bit, and I hope that our listeners did as well. I'm sure they did. Thank you once again for being with us today.
Thank you.
Thank you.
And thank you to the Horace Mann League for hosting this podcast. But most of all, thank all of you for listening. Have a great day. Be well and be safe.